emotional well-being, I guess, in the
Yes.
house, a comfort in knowing that you've got some planning done. We're talking with Kristen Davis. First of all, it's Thanksgiving, so I want to thank you for having a name I can pronounce.
There you go.
Very important.
Very easy.
Very easy. So you're an attorney. You've had a journey to get to your own practice now, so you've got your own firm, Kristen Davis Law, LLC. That's your firm. You're located here in Eagan, right?
Yep.
In Eagan. Okay, let's go back and say, how did you get here? Where'd you start out? Just a little background for the listeners so they know that you know what you're talking about.
Yeah, perfect. So I graduated law school at Hamlin Law School in 2007.
Okay.
And so I worked at a law firm in Eagan, have been very local this whole time. So I worked at a law firm till about 2012, 2013.
Mm-hmm.
And then at that point...
What'd you do at that firm?
Yeah, so I did the same stuff that I do now. So
Okay.
I do a lot of family law, so divorce, child support, custody, parenting time, restraining orders. And then I also do probate. So if someone passes away, I help them administer the estates. And then I also do estate planning. I tend to do more basic estate planning. So people that come to me are usually under $3 million for total assets. And I'll do... wills, power of attorneys, healthcare directives, transfer and death deeds, and stuff like that. So I worked at a firm for about 5 or 6 years and had some kid health issues around 2012, 2013, and realized I needed to have more flexibility with life and try to do that balance. And so around that time, I started a firm called Molinaro Davis Law and had a law partner, and we were located off Cliff Road in Burnsville. And so we were Molinaro Davis Law up until a few years ago when I started then Kristen Davis Law.
Okay. A couple of things are just kind of splashing through my mind here now. So it's like the ocean.
Yeah, the water's, yes.
I mean, first of all, partner, eliminating partner. Tell me about that a little bit.
Yeah, so, it was a friend of mine, a good friend of mine, still a good friend of mine to this day. I talk to her every day, actually.
Okay.
So her name is Teresa Molinaro, and so when we first formed, I have 2 kids. She had 3 kids. We both were on the same page. And post-COVID, I think Teresa just wanted to do something different. And so it was very amicable. It was fine. She went to a large law firm at that time, and then she actually has since left then and is now at a bank doing trust work.
Oh, all right.
And so actually when we were in the law firm together, she did all of our trust work, guardianships, conservatorships, didn't touch family law, and then I did all the family law, probates, estate planning. So we never really did the same stuff, just kind of complemented each other. Mm-hmm. And then we also had employees and other attorneys and legal assistants. So I've had kind of different avenues of where we're at. And now where I'm at, I have a full-time assistant and then myself as the attorney. And so that's kind of where we're at now.
So you are practicing in the area. We have 2 specialties that we focus on. One of them is high conflict divorce, and the other one is probate.
Okay.
So it's just the tie-in is perfectly. In fact, I saw your name on a case I came across from Dakota County, and your name was on there. I thought, well, gee Williker, she's right down the street from me. I got to give her a ring-a-ling and see if she can come in and talk to our audience about that area of law in particular. But I want to go in 2 different directions here. I want to talk about divorce and I want to talk about probate.
Uh-oh.
So which would you rather talk about? What's your
Both
favorite?
are very difficult areas.
I know it.
Someone's dying or someone's getting divorced.
Yeah.
That's kind of like dying.
They're both
there's a
well, maybe not.
grieving process
Maybe not.
on both.
Right.
Yeah.
Dying, but living.
Mm-hmm.
So my attitude about divorce is it's a fresh start. So you have a obviously the couple loved one another at one time or another. They wouldn't have gotten married, and things have happened during the course of that relationship, and it just is fractured to the point where it can't be glued back together. And so now it's like we got to figure out how we're going to move on. Sometimes there's resentments that come up, and so then there's vengeance and all of those things that play in, and the for me, I'm just kind of down the middle kind of a guy. So I mean, I just kind of take it what it is. Our goal here is to separate and get rid of it. How do you deal with that when you have someone that comes in and they're just like they want to kill, right? I mean, they're just so angry that they just want revenge almost as much as the separation. In fact, they want to drag out the divorce just to inflict pain on the other side. Do you see that much?
I do, but I don't know. A lot of times what I see is that people don't even realize that that's what they're doing. They're so emotionally invested. And so whenever I have clients come in, I always tell them, okay, here's the deal. How this is going to work is going to depend on the reasonable and rationality of 4 people. And that is going to be my client, their ex or their soon-to-be ex, and then both attorneys.
Mm-hmm.
You get one irrationality or unreasonableness in that group of 4, then that's what I tell them, that's what court's for.
Right.
So you can't mediate, you can't settle if someone's completely unreasonable or irrational. That's what the court system is for. And so sometimes when I get a case and there's a trigger by the attorney, or I can see the other party hasn't caught up emotionally in terms of accepting that they're getting divorced, or they carry that resentment, or they're not there yet. So majority of the cases do settle, about 93%, give or take.
Right.
But that other 7% end up in a trial, and I can usually tell you what cases are going to trial. But when you first start out, sometimes a case will just take 10 steps. It'll take to get to step 8, where their emotions and all of that
by the time they
catches up, right? And so majority do settle, and they might come in flailing in the beginning, but the court system, probates, family law, takes forever, right? Especially right out of COVID, it would just take so many delays. And so usually they come in strong. Eventually they kind of see, okay, I got to move on. I mean, this is reality. Right. And with my clients too, I always say, here's the deal. I'm here to give you the tool. I can get you divorced, but all that other stuff, right? Taking care of yourself, the healthy, the wellness, therapy. I'm not your therapist. And I make sure there's a real clear line on that, because they need to do all those hard things. Go to the gym, go to, friends, family, your support network. I'm just there to get you the tool. There are laws in place. People forget about that, but in family law, there are laws. So there's going to be a child support calculator. There's going to be laws about spousal maintenance. What's in the best interest of your kids? And so I'm there. I really make sure I do not get emotionally invested. Obviously, I understand. I'm sympathetic, empathetic to what they're dealing with. But my role as the attorney, it's like a doctor. They're going to give you the diagnosis. But there's a whole load of emotional well-being that needs to go with that. But that's not my role. My role is to get you divorced and get you everything that you're entitled to under the law in a divorce.
Is because the holidays, right? They bring up so many things with families and issues and whatnot. Do you typically see that being a harder time of year?
For sure, especially high conflict divorces.
At the holidays.
Well, because all of a sudden you're going, okay, we have a regular parenting time schedule, and then all of a sudden anytime there is a way to have conflict, that's what gets thrown in there. So one, I see it where, okay, all of a sudden now the parenting time schedule is changing because it's a holiday. Holiday's going to trump the parenting time schedule. So what time is the exchange? Is it an odd year? Is it an even year? The other part that I run into is all of a sudden now you're getting like Aunt Susie's opinion, Grandma Joe's, Grandpa Joe's opinion. And so where they might be, okay, I think we're going to have an agreement. Now they get, unsolicited or solicited advice from 12 different family members at Thanksgiving. Then come Monday, I got like 12 different proposals and opinions and whatever else.
Too many things what should be.
What should be. Too many cooks in the kitchen.
Third-party influence, we call that.
100%.
So we always look at, when we get involved, we're looking at the situation. Obviously, when there's kids, that's a circumstance. Do you see a difference in a high conflict? Are kids a factor that creates more conflict, do you think, or is it just another thing in a
Yeah, I guess it's what I see as the most litigated areas. Number one is kid stuff, right? Parenting time, and custody, and the second is spousal maintenance. It's where whatever the financial exchange is for alimony. Kids stuff, you're already taking a high conflict situation, and anytime you add extra stressors, kids are great, but they also add so many layers to it. So yes, but there's also mechanisms. You can do custody evaluations. You can get guardian ad litems. There are more tools to help those issues.
We see that they fight over this silly stuff, like who's going to paint, who's going to paint, who's going to pay for it, all those kinds of things. We'll pick it up right after the messages. This is Our Healthy Homes, ourhealthyhomes.com. Back with Kristen Davis, attorney. We're talking about divorce, and we're going to talk about probate as well in the upcoming segment, so stick around. Hey, welcome back. Thanks for sticking around. This is Our Healthy Homes. We're speaking with Kristen Davis, attorney. We went out for break last time. We were talking about high conflict divorce. People fight about anything and everything. We find that we get involved when the house has to be sold. Which, what do you think is the percentage of time that happens when the house has to be sold?
I say it happens enough. Even with the interest rates these days, right? It's hard. It happens enough, right? So usually you have a home, but then if one person's being awarded it, they obviously want off the mortgage. Mm-hmm. And then to refinance at different times, you're obviously not refinancing or selling because of the market. You're doing it because of outside sources, which is your divorce. So it's usually either the worst time or not.
It seems like it's always the worst time.
And it's not the best time. So I would say, I don't know. I don't even know if it'd be 50-50, but houses get sold quite a bit during divorce, or at some point in the divorce.
During the divorce.
Yep.
And that's when we get them. And people fight. We find they fight about who's doing the paint. We had one where the house had to be painted, carpet had to be cleaned or replaced, and of course you're like, well, I'm not going to pay for it. And I'm not going to pay for it. Neither one of them were living there.
Yep.
So they're just arguing over who's going to do it. So what we do is we just go and say, we'll do it.
Wow.
We'll do it. We'll pay for it. We'll settle up at closing. Just take it off the plate.
As an attorney, I would say thank you.
Yes,
I would say yes, that's great. If you're willing to front that and get it in the end, and then everyone's dividing it up anyway, I would love that.
And then I'm using my person.
Yep.
And you guys don't need to fight about it.
Right.
I'll
we
choose
know what's
the
going to
color.
Get done.
And there's not two different painters. Each
Exactly.
got their own.
Right.
Yes. Ooh, I love that.
It's always like that.
Yep.
Fight and bicker.
I would like that.
Take the temperature down is the main thing. I want to talk about probate a little bit because I love probate.
We do.
It's well, I mean, same thing. I guess with divorce, you're dealing with a time of people's lives when it's a high emotional time of their life, and I like working with people where the personal rep is out of state. Because that happens a lot where grandma or uncle kicked the bucket and you got a nephew who's in California and he's the personal rep. He's like, oh, how am I going to do this? So we'll do the same thing. We'll go in, we'll evaluate the property, and many times you'll hear sell it as is, and selling it as is isn't the smart move. I mean, the smart move is to paint it, put some carpet in, doll it up.
Get the most that you can.
And you get the most you can for the family, because sometimes it's worth. We got one this year. We got $95,000 more just by going in there and cleaning it up a little bit.
Yes.
And same thing. We pay for it all and settle up at closing. And just it's great. Takes it all. I just say, don't worry about it. I'll take care of it. Talk to people about probate if you can. And trusts and all that, and what's the smart move? Should we put the house in a trust? Should we not put it in a trust? How does the will tie into that? Many times you'll hear people say, well, I have a will. I don't need to put it in a trust. Can you speak to that a little bit for people?
Yeah, so, and I actually teach estates, probate, and trust course at the law school as an adjunct professor, and I also do a write your own will class through a bunch of community education programs. So I'm constantly educating people on probate.
Is that online or in person?
So I teach at the law school as an adjunct professor in person.
Okay.
And then the community education programs, those are through like District 196, District 191, I think I'm at 191, but Hastings, Matamidi, I'm all over the place. So when you look at your community education catalog, there is literally a write your own will class, and so it is the most cost-efficient way to get a will. And I always tell people, everyone needs a will. I don't care, even if you just have some furniture, and I call it your crap, right? Your tangible personal property in your home. You're getting control over that. If you don't do that, the state of Minnesota decides who's in charge and who gets your stuff. Why not put that control, whatever you may own, right? So when I do this class, I'm constantly educating people about what probate is versus non-probate and what they need, just because people get very confused. So with probate just means you have to go to court to get your stuff to the beneficiary. So no matter what, you die, you want your stuff to get to the beneficiaries. Probate just means it's an added step, meaning you have to go to court in order to do that. Non-probate means you have a automatic distribution that's still going to your beneficiaries. So we're still getting, I call it A to C. You're still getting your stuff to see the beneficiaries. You just don't have to go to court. So that's going to be like a life insurance policy with a beneficiary. That's going to be a pay on death account, a beneficiary, a transfer on death. All of those mechanisms automatically transfer your stuff because you died to your beneficiaries, A to C. Super slick. So when you have a will, your will goes through probate, meaning you have to go to court because you don't have a named beneficiary. You're the last of the spouses to die, and your home is owned in nobody's name, right? That's going through probate. If you have a will, the will control about who's in charge and who gets your stuff. If you die without a will, state of Minnesota decides who your closest relatives are. Now, when I first started practicing in 2007, we did not have something called a transfer on death deed.
Yes, I know it
well. TODD. So when I first started practicing, the first few years, the big push was, you got to do a trust. You got to do a trust. Why? You want to avoid probate, meaning you want to avoid going to court. We hate lawyers. We don't want to deal with the court system. It'll take forever. So when I first started practicing, it was this huge push to trust, and it made it overly complicated for people that own like a home. They have some retirement, savings account, investment accounts. They didn't necessarily need this whole trust mechanism. If you have a trust, you got to transfer assets in the trust. You're not the owner anymore of these things. Trusts are good for certain purposes, taxes, privacy, secrecy, not joint families, right? There are reasons to do a trust, but it really became this issue. And thank goodness the legislature came out and they came out with a transfer on death deed. Slickest tool, my favorite estate planning tool that in my career that I've seen that have helped so many families. Transfer on death deed, what it does is it takes that you have a home, right? You have real estate. It's usually when the second spouse dies. It takes it out of going through court to probate to get the home to your beneficiaries. Because what you do is you do a transfer on death deed, and it'll literally say, on the last of the two spouses to die, I quit claim the property to Susie Q and John Q. Right? And so what it does, it has to be recorded in the county recorder's office. And what happens is, as long as it's recorded during your life, that transfer on death deed will make your real estate become one of those non-probate assets. So you die within a day, 2 days, you own that home.
What happens when you have multiple recipients? And so you've done a Todd, and now it's in 3 people's names. And one of them doesn't want to sell.
Yeah. So my rule of thumb is 4.
Okay.
And that's based on nothing besides I've done probate litigation. You got more than 4 kids, someone's going to throw the wrench in it.
Mm-hmm.
Everyone's got the crazy aunt or uncle, and they're not going to sell it, and they're going to muck it all up.
Right.
So transfer on death deed, there are certain times where it's appropriate, but it's not appropriate for everyone. If you have minors, you can't deed real estate to minors.
Right.
So you got to wait until they're of age. If you have more than 4, why would you do that, right? If you just have it go per your will, one person's in charge. The 4 people might all still be the beneficiary, but they're not all owning the real estate together. But a transfer on death deed, if you have 2, a married couple, they have 2 of the same children, and they do a transfer on death deed, both kids are over age 18, they get along, super slick. Last of parents die, bam, 2 kids become the owner.
What are your thoughts about transfer on death into a trust? So
yeah, you could also do that. That's also another.
So that kind of
mechanism.
takes all that off. So now you got a trustee who's they have to liquidate the house now, because that's the only way that you can clear the probate, is to liquidate the house, because it's not going to sit in the trust for 5 years.
Well, I guess it depends on how the trust is.
Mm-hmm.
If the trust provides that certain people can live there, reside there, but it's really going to be that trust mechanism. But yes, you could do that. Also allows you to not transfer your home or property into the trust during your life. It would be on your death. It would then go in there.
Now, I visited with someone recently, and they had, because they have cars.
Yeah.
Right?
Yep.
They had transfers of cars on death.
Yes.
So I had never even heard of that or thought about it. Tell us about that.
Yeah, so that's new too. And I think it's only happened I've only heard about it in about the last year. And I heard about it through one of my community education classes where someone who was taking the class and they're going, oh, I heard that the DMV has this. And so I haven't myself checked it out, but I have also heard that. And what that would do is that would take your car out of probate and then immediately upon their death. The best part about these, it gives no present day interest. So whoever you're giving it to, they file bankruptcy, they get divorced, whatever. There's no liability because they have no present day interest. So that's another mechanism.
What about animals like horses? Like that's a big commodity.
They're
like cars.
Tangible personal property.
Oh,
okay. Right? I know. All those dog and cat lovers, I'm sorry, but that goes in the whole realm of your stuff, your crap.
Your stuff.
Sorry.
Along with your scrapbooking.
Exactly.
Well,
yes.
My
this
oils.
is Our Healthy Homes.
My oils.
.com. Our Healthy Homes. We'll be right back. Welcome back. Thanks for staying with us. This is Our Healthy Homes, fourth segment of the big program. Kristen Davis is in the studio. We're talking now about probate and estate planning.
I got a question.
All right.
Uh-oh.
What is the most screwed up thing that people do when they try to do things on their own, or you see other attorneys that really don't do it the right way?
And we're talking in the context of probates.
Yeah.
Yeah.
Yes.
So
yes.
I think what I would say about, and it's more in your realm of realtors,
Okay.
I would say actually the biggest part when I deal with realtors in selling real estate through a probate is in terms of what type of title the personal representative can convey. I swear, I'd say 90% of the realtors I have dealt with get that wrong.
I believe it.
And the biggest piece is what type of deed, right?
Mm-hmm. Yeah.
And so normally when you sell real estate, and this is in your realm,
Right. Yep.
right, you're going to give a warranty deed,
Yep.
and that's what people want.
Right.
And when you deal with a probate, you absolutely, the PR cannot give a warranty deed.
Right.
It has to be a personal
Personal rep deed. Yep.
representative's deed. And it's on the standard forms.
It is.
It's just a different box.
Yep.
But as an attorney, I always have to review the purchase agreements, and I will tell you that I immediately go to that line
Right.
and change that probably 80 to 90% of the time. And so when I in the context of probate, I represent as the attorney for the personal representative. So they check in with me before they do things, and I always say, okay, they hire their realtor, and then I'll say, okay, before you sign a purchase agreement, I have to review that.
Mm-hmm.
And that's the biggest piece is they provide a personal representative.
And some realtors get all twitted out about that because they don't think that you need to, right? It's just what they think. But then they think, well, how long is that going to take, and how much time is that going to take? And I'm dealing with whatever it is. But yes, there is a reason to have that checked over because of what you just said, because most realtors do not understand probate. They don't understand how it all works.
The timing of it all.
The timing of it. I mean, even the same thing, with the divorce. Most agents do not know how to emotionally deal with high conflict divorce.
I have had some of the worst litigation cases have been probate, or even more than divorce at times, because you have siblings, right?
Yes,
You bring all the family issues that are all like under the
Since
surface.
they're 3
Yes,
years old.
right.
Yeah.
Oh yeah.
Yeah.
And then someone dies
Yep.
and oh my gosh, and it's also this sense of entitlement.
Yes.
So when people do their estate planning, I'm constantly like, here's the deal. It's your stuff.
Right.
Leave it. You can leave that to neighbor Bob down the street. Right. That's up to you. Absent there are some, if you're married, there are certain spouse rights that you can't waive, but ultimately, you don't have to leave your stuff to your kids. You can decide. But then when they die, you run into this family tension. All the stuff comes to the surface, and then also that feeling of entitlement. I will say, though, when real estate is sold, and for realtors, I think the more high conflict issues are for a divorce. Because one of them usually doesn't want to sell it, or they're fighting over like who's painting and whatever else. As part of a probate, as long as there's an executor or personal representative who's appointed, they're in charge. So
yes, right.
absent not, selling it for market value or something like that, I mean, they're going to have the discretion to ensure the paint colors and the painting and that kind of stuff. I very much appreciate a realtor who has experience with dealing with probates. That is a huge one. I mean, they'll know how to list it, how to sell it. My client has to sign as personal representative. That's a huge one. The PR deed. I love when they have any sort of experience.
We have visit with people depending on when first of all, there's a lot of people who want to do it themselves. I think they do a simple probate and they don't need an attorney. That's just flat not true.
Yeah, and when I deal with, and I will tell people there are certain areas of law where I'm like, here's the forms. I think you can do it on your own. Probates, no way.
No way.
The reason why is because the PR or the personal representative, they take all the fiduciary obligations.
Yes.
They take all that responsibility. If you do something wrong, you got 4 people.
Oh.
They're all pointing the finger at you.
Oh, yes.
And so why wouldn't, and it can be, your attorney can be paid through the estate. So why would you monkey with that? Why would you try to do that?
Right.
And so the court system they set up this like informal probate system. They tried to make it more pro se friendly. I just tell people, I've seen it. I've seen the forums. It's so form driven. It's so timeline driven. Don't monkey with it. Hire an attorney. That's one area I would say. Also a divorce.
Yeah, because you teach on the will. So somebody could do like you said, you teach on the will. That's a piece that they could fill it out and do it themselves.
They literally come to my class, and the class is called Write Your Own Will. They leave the community education class that night after 3.5 hours with their own will.
And when we post this online, we'll put all the contact information for Kristen so that you can get a hold of her. One other thing that I see is especially with a probate, so you go into the house, there's all this stuff, right? And then you meet. If we're lucky enough to meet with the personal rep before they start liquidating things, and other family members will go into the house and they'll literally loot the house. I mean, they're in there grabbing.
Yeah.
And it's like, you're the personal rep. It's your responsibility to protect the assets of that estate and distribute them in a reasonable manner, not just to let, wink, wink, your sister come in because she wanted the piano, and all of a sudden the piano is gone, and then the other sister said, "Yeah, I wanted the piano," or whatever, whatever the items are, gold, jewelry, and all of that kind of stuff. And then, well, Mom wanted me to have that, and so okay, well, it didn't say that in the will that Mom wanted you to have it. So how do you know that? Sometimes you'll see things tagged, put boxes with someone's name on it. Okay, I get that. But the coming in and looting of the house is a frequent thing, and I was like, man, you get her. And a lot of times that's with someone who has not had counsel, so they haven't sat down with the attorney first before they move forward, and it's just like the wild, wild west out there.
Yeah.
Okay, so let's talk about then what a family can do now in anticipation. You got Mom's 90, and she's living in the house still. Your dad has passed away, so Mom's been living in the house for the last 10 years alone. What kinds of things should they do? So they're coming in to see you, probably for the first time. Kind of walk us through that conversation. We got about 4 minutes.
Yeah, so I always what I tell at a minimum everyone should have, right? A will, a power of attorney, a healthcare directive, and then the transfer on death deed if it's appropriate.
At a young age, like you mentioned,
Well, we're talking about
I know, but what I'm
situation.
saying is, I don't want people to think that they don't
They
have to
can
worry.
wait. Yeah, you can get hit by a bus tomorrow.
Right. You
well,
need to.
and not only that, it's capacity, right? So you have to be competent or have the capacity to execute these documents. So what I tell people, what Sheila's bringing up, you do it while you have the capacity when you're young, and then you tuck them away so that you have to pull out those documents when they're needed. A 90-year-old, you got to really look at it. Is there any dementia? Is there the start of any dementia? Can they live on their own? Because then you start getting into capacity or competency, which you don't want these documents to be objected to later.
Okay.
Well,
right?
and documents objected to that are outdated documents. So, like, grandma, 90, mom, whatever, might have had everything done, but the last time
20
she
years
did it
ago.
was 20 years ago,
Right.
and now this kid's dead, and this husband's dead, and there's
This couple
grandkids.
got divorced.
Right, so yes, it's great that you have one, but how often do you advise people to review it?
Yeah,
or update it?
So usually when people have kids that are minors, right,
Okay.
you need a will. Who's going to be the guardian?
Right.
That's huge,
Right.
right? And so then once your kids are emancipated, then you might want to name them as the personal representative, your power of attorney, your healthcare directive. And then I kind of tell people any big change of lives, right? Obviously, a trigger is divorce. If you get divorced,
Right.
your kid does, whatever,
Right.
that would be a trigger. A death. Sometimes people die out of order in our
Right.
heads.
Right.
That's a big one,
Yes,
right?
it is.
So any sort of death, and it might be out of order, might not be spouse. Obviously, if a spouse dies, any medical, and I feel like these are natural triggers for people. So, if someone's in the hospital, that might trigger them to kind of think, oh, I got to make sure I have all these in there.
Pull this out again. Yep.
Yeah. So if someone did come into my office, right, whatever time frame they're at, the will, power of attorney, healthcare directive, and then that transfer on death deed. And the biggest thing I'd say on power of attorney is people always get those very confused with personal representative. They're not the same thing.
Right.
Power of attorney form dies when they die. It's only alive when they're alive. So people call and they'll be like, I'm trying to pay my grandma's funeral. I'm her power of attorney. Nope. That form dies with you. And so power of attorney form, you're giving someone power for financial, real estate, transactional power during your life. And then when you die, then you have your will, and that's where the personal representative comes in. Power of attorney does all of those things where you delegate someone except for healthcare decisions. So that's where the healthcare directive comes in. And that is who's going to make a medical decision because you're unable to do so. You're going to trump everybody. No one's going to trump you, but who makes that decision if you're unable to give it?
So if you are listening to the program right now and you're thinking, geez, I don't have any of that stuff.
Get it.
Kristen Davis Law Firm, give her a ring-a-ling-ling. The number's in the notes, and her website is in the notes. Go there, have an appointment, sit down with her, have a consultation, and she will help you make a healthy home, peaceful mindset in your healthy home. This is Our Healthy Homes, ourhealthyhomes.com. We'll see you next week.
But when he calls me sugar, I love that man with all my might. Sugar in the morning, sugar in the afternoon. Sugar after dinner, sugar in every room. He says I'm sweet as I can be. When he calls me that name, it does things to me. I tell